Hi, everybody. This is episode 24 of Immigration Talk with myself, John Khosravi, and my wonderful associate, Anna Sergeeva. Thank you for joining us. It's May 26, 2022. We want to just jump in and talk about a topic that's very important because we've been getting so many messages about it. And this is people who primarily do an I-130 family case, but I-140 employment-based cases as well. And they mistakenly list that they're going to finish the case in the United States with USCIS, do adjustment of status, where in fact they're overseas, and that beneficiary of that petition, the person overseas, the family member or the employee, is going to do consular processing. When you mark that you're going to do adjustment of status, the case stays with USCIS in the United States, and it becomes a whole mess of a problem to try to have it taken out and sent to the embassy. So that's what we're going to focus on today, just on this topic. Anya, thanks so much for joining us today.
Thank you so much, John. How are you doing?
I'm doing good. We get this issue like pretty much every day, emails on it, and it's always sad to see. So it's a sad topic because it's going to be a headache that we're going to talk about. But before we do, actually, a reminder, you make sure to like and subscribe wherever you're watching, and leave comments. We'll try our best to respond, or at least do videos if we see certain comments pop up. But Anya, could you outline the issue, what people do, and then what some stuff that needs help? What is the main problem again? If you could reiterate it.
Yeah, so John, if you have I-130 in front of your eyes, if you can just bring it to the screen, it's going to be very helpful. So there is this one, not one, but a couple little boxes on I-130 that are very important, and unfortunately, a lot of people get it wrong. What I'm talking about is I-130 form, which is petition for alien relative when you want to bring like your spouse, your child. From overseas, your brother, your sister, all the preference categories too. It works for that as well. So the form asks whether you want to apply for adjustment of status in the United States. It's as if the beneficiary is in the United States. Yeah, I think it's like page 8 or something, or 6. So that, yeah, just we're gonna bring it up.
So, there's a first part in there on page, where is it? Page 7, I think, where it asks if the beneficiary is currently in the United States on the bottom left. And so some people, they're not here, but they fill it out, they put numbers in here. So that confuses them right there. They may have been there for tourism or something like that and left, but they put that there. And then more importantly, on page 8, there's a part that says the beneficiary is in the U.S. and will apply for adjustment of status, and they list the city and state where they're in. Or alternatively, or the field offices, or on the top right of page 8, it says the beneficiary will not apply for adjustment of status in the U.S., but he or she will apply for immigrant visa abroad in the U.S. or consulate. This is the killer right here. This really becomes a problem when people mark this incorrectly.
Yes, unfortunately, and even some attorneys get it wrong. It's this mistake happens, but it's critical. It's crucial what it can lead to. It can lead to very lengthy processing times, and basically, as John mentioned previously, so what happens is that your case stays in the United States and it doesn't move forward. It doesn't go towards the visa processing. It doesn't go to National Visa Center. It doesn't go to the embassy. It just gets stuck here, and that's it. So this is the problem.
Yeah, it's messed. So people contact us like, what do we do now? And so there's official stuff you have to do. We're going to talk about. There's unofficial stuff, and there's backup plans. There's a lot to do, but it's all going to be a lot of time spent, maybe to no end, and it might end up costing a lot of money. Unfortunately, it's a very small mistake people make, but it creates a lot of havoc. So before going the formal route, which is what they want you to do as Form I-824, what are some options to kind of push it and try to get lucky that people could do?
Yeah, one thing I just want to bring up right now, in the receipt, not in the receipt notice, in the approval notice, first paragraph, you will see that they're going to tell you, hey, you marked that the beneficiary will be adjusting status in the United States. So if you want them to consular process, you need to do it's called I-824 form. It's what it's called, petition of, I forgot what it's called.
Application for action on an approved application or petition. I'm reading it right now. I haven't memorized.
Yeah, something like that, right? So basically, it's very short form, but it serves to ask USCIS to move your petitions that already has been approved for further processing to the National Visa Center. That's what it does. This is the official route.
Now, the I-24, it's simple, but they made it into the worst form possible to complete. If you're going to do it, you're going to get really confused. Any immigration or whoever it is, it's so badly designed and confusing. Frequently, when people do it themselves and we see it, there's pretty much they did it wrong. But unfortunately, the form is really badly designed. But I'm glad you brought up the receipt because there are cases where you did properly say, I'm going to do consular processing. And I've had this before, but we get the receipt notice and it says you marked for adjustment of status. And we have a copy and we say, no, we didn't do that. And so I had one case, it was out of Chicago, it was a marriage case. And we told and called USCIS, called them. They say, we'll look into it. And months go by. We keep calling them saying you did an error. They wouldn't accept it. Got a congressperson involved. They kept pushing it. It took 4 or 5 months of every month pushing them for them to say, oh, yeah, we did make a mistake. The file did say consular processing. We said adjustment. And they sent the case out. It was going to be in France processing over there in Paris, France. But so it's really important when you do get your receipt notice and you're waiting for the National Visa Center to contact you, which is the format when you do an I-130 and then the National Visa Center comes to finish it off. Check your receipt to make sure they didn't make a mistake because you might have been right. They made a mistake. It's not, that does happen. But okay, so this happens, this error happens, and the fault is of the petitioner. They fill the wrong box. What are some quick ways to try to, talk? And I talked briefly about contacting USCIS different ways. Could you go into more detail on those?
Yeah. So as I mentioned, official way is to file I-824. Okay, but this application is not very consistent. We get in very different timelines for that. Some cases get like 3 months, some cases pending for a year plus. So it's unfortunately it's very inconsistent. So what else can be done even before filing I-824? You can reach out to NVC, National Visa Center, directly, saying, hey, can you please move my case for further processing? The embassy too might work, so they're gonna initiate the process from their side. But again, we haven't seen it work in a long time. Probably it has something to do with COVID. We're not sure, but you should always try to do that first. Go kind of, I don't know, different route, because it might
Yeah,
be faster rather
and
than
call you
filing I-824.
even and see, hey, could you fix it on your end? Get a congressperson involved. Say, I made this mistake. Depending on how much of a go getter the congressperson or senator is, or at USCIS who the person is gets it, they can do whatever they want to do. It's just a matter of taking a package and then pressing a button. Essentially, it's not that complicated what they're doing necessarily, but getting to do it's a hassle. So yeah, there's congressperson, call USCIS and keep pushing them. Contact the National Visa Center, see if they can do something. The embassy. Most of it's not going to work, but sometimes it works. So it's like you give it a shot and you throw everything in the kitchen sink at it. But have an I-824 prep because that's gonna be the way to go. The I-824, you can find the form online. You got to mark the proper box, which says, I indicated that move the case from. Let me pull it up exactly. I'll read what it says. USCIS to notify U.S. consulate. No, that's not the wrong one. USCIS to send my approved immigrant visa petition to the National Visa Center. So it's that box, and to really get it out to move it there. Now, I-24, you submit it. It could be done in 3 months and you get a notice it was approved. It could be more than a year. I've had colleagues have to do lawsuits to get them to do it. But even after it's approved, I've had cases where after approval, we got to call them every month to say, hey, how come the case hasn't moved to the National Visa Center? You approved the I-24. I had one case for 5 months. I'm calling every month until finally it went to a tier 3 supervisor in Washington, D.C. And they're like, I'm really sorry. We just keep dropping the ball. I'm going to fix it for right now. Within 24 hours, it's fixed. So that's the thing. We always want to avoid from I-824. It's a nightmare to deal with. And that's why sometimes we have a backup option and say, listen, maybe just redo a new I-130. That may happen faster. We can send proof that was approved once before, talk about our error. They may approve the I-130 faster. And to add extra levels of complexity, if you're a U.S. citizen, you file an I-130 and also do a K3 I-129F. And it's too many numbers going on. I don't want to confuse people, but you kind of do everything. I-24, calling this person, emailing that person, I-130, K3, I-129F, and see whichever one works fastest because you got to get the case to the embassy because from a lot of countries, you can expect even more delays once it's at the embassy, at the National Visa Center, getting embassy appointment. So there's a lot of delay baked in this cake. And so you just kind of go all out approach and throw everything at them and hope something sticks.
Yes, unfortunately, that's how it works. And again, due to we don't know how much time it's going to take, we cannot tell our clients what is better to file I-824 or to file new I-130, for example, because sometimes new I-130 might work so much faster rather than I-824.
Yeah.
So
Yeah, and you do expedite. Sometimes you have an emergency humanitarian reason. It has to be done faster. You can do that with the I-24, you can do it with the I-130. But I mean, there's costs associated, filing fees, there's attorney fees if you're using a lawyer. But it's just one of those things. You just do everything. And this morning, the reason why this came out this morning, we finally got a case moved to the National Visa Center that was stuck because of this error. And we tried so many things, hard to even tell which one of them it was, because we were calling, the client was calling, we were sending letters, client was sending letters, we were contacting senators, client was sending congressperson. Like, we did everything for months and months, like tens of hours really on this case to get it in. And it finally works. So the case can move to the embassy, but then we got to deal with that and see how long that's going to take. So that's a whole step two of stuff we got to deal with. But at least we got the case fixed and moved forward. And I don't know, I think we started, what was it, November, December when we started? Now it's May or so. It took some time, but we got it out. But it just requires so much legal work. And so when people do call in the I-24, first thing in my head is like, oh man, they'll be in for a wild ride. As the attorneys working on the case, I wish I never had to work on I-24. You think with these new technologies that they have, it's really easy for them, like, oh, just let it go. Why do we have to submit a new form, new filing fee of $465 for I-24, delay calls? Why does it have to be like that? Just be like understanding, like, okay, we'll just switch it up. I don't know the internal systems. It seems like it should be that easy, but that's just what
it
we're
doesn't
doing.
doesn't look like it. Yeah, I just want to mention too that when you file in, for example, I-130 petition for petition for alien relative, and you don't know, right, that whether the beneficiary will be consular processing or will be adjustment status in the United States, it's always better to put consular processing, because it's so much easier to move the case from consular processing to adjustment of status rather than vice versa.
So
Because
important. So
yeah,
important. Yeah, because if you say adjustment status, to get it to the embassy, you have to file the I-24. But if you say the embassy and you adjust status, you don't have to do anything. I'm not sure why it's
exactly.
one way like that, but that's
Yeah,
so you always want, and like we have actually employment-based cases too sometimes, and some lawyers mark adjustments. Like, if you're not sure in any way, even if you are sure, always do constant processing, unless you're going to concurrently file a form I-485 for adjustment status with the I-130 or the I-130 or 40. You always really want to do constant processing and say that, and then change it up if needed. It's not a big deal. But yeah, that's such an important thing. So this is tips we give other lawyers and grace lawyers. A lot of time we're training them. It's like, always go towards constant processing because it avoids the I-824. You want to avoid that one like the plague, or like COVID. I guess that is a plague of sorts.
yeah, exactly.
Wonderful. Well, thank you so much for sharing that. Everyone who's listening is into this case situation. We're getting so many emails on it. I know a lot of people are dealing with it. Hopefully, the information helps you a lot. You're going to be going through some stress in life. Prepare for it. The more prepared you are, though, the better it's going to go. And we got that case done in 6 months. Could have been longer. Again, we have colleagues who end up having to sue the government because they just don't do anything. And it's hard to say what actually worked pinpointed, but it was just, I think USCIS probably got fed up. They're like, those people are annoying the hell out of us. Just get this case out of here. Every day is a congressperson, a senator, the embassy, the National Visa Center, this calling, that calling. They're like, just get this case out. And that's just what you got to do sometimes with
Yeah,
law. It
and
just be so annoying.
I'm so happy. I'm so happy for our clients, but it's not. They're not even here yet. It's just we did so much just for the case to be moved to the National Visa Center.
Half
There's a
the
whole
cases.
bunch of other like consular processing step, dealing with the National Visa Center, dealing with the embassy. It's the whole like world by itself.
Yeah.
Yeah. So
Definitely. Well, thank you so much, Anya, for sharing the information. If y'all haven't already, just like and subscribe to catch more videos like this. We have the podcast as well. Just put our names in there, JK Law, everything should pop up. But this is our new channel name, U.S. Immigration Talk, because that's really what we're doing here. The name of the show is going to be the name of the YouTube channel if you're listening on YouTube. And if you want to schedule a consultation, just email us, info@jqqlaw.com. That's for me, or Anna@jqqlaw.com for Anya, or Anna, and or Anya. We call them both ways. But thank you so much, and we'll see y'all soon.
thank you so much, John. Thank you everyone for watching, and see you next week.